Hey, my name is Ben Brodish and I'm an attorney with Krieger Brodish Law Firm. So today I'm going to talk to you about the process of filing a lawsuit in North Carolina. The first thing I'll say is that filing a lawsuit in the litigation process in North Carolina is complicated. There are tons of technicalities and nuances to the legal process, so I definitely recommend working with an attorney when filing a lawsuit. The first step in the process is to file the lawsuit. The key document that has to be filed with the court is called a complaint. A complaint acts to summarize your claims against the other party. After you file the lawsuit, the next step is to serve your lawsuit on the other party. There are several ways to serve a lawsuit on another party, but this is a critical part of the process and one that's necessary for you to pursue your case in court. Number 3, after you serve your lawsuit, the other party files a response. Usually this response is called an answer. The answer is the defendant's opportunity to respond specifically to the claims asserted in the complaint, and also to raise different defenses that they might have. Number 4 is discovery. Discovery is the phase of the legal case where the parties exchange information with one another. Depending on the case, the discovery process can take a long time. There are 2 key discovery tools that you should know about. The first fit into the category of written discovery. Written discovery essentially includes different types of written questions that the parties can send one another. Things like interrogatories, requests for the production of documents, and requests for admission. The second of these key discovery tools are called depositions. A deposition is essentially an interview of a party or a witness taken under oath. So for example, the plaintiff often has the right to depose the defendant as well as other witnesses that are relevant to the case. After discovery and just before trial, there's a stage called mediation. Mediation is required by the court, and it's basically a meeting between the 2 parties where the 2 parties attempt to negotiate a settlement before trial. At mediation, the 2 parties use what's called a mediator. A mediator is usually another attorney who serves as a neutral, sort of an in-between between the 2 parties. It's somebody who helps facilitate the settlement discussions between the plaintiff and the defendant. After mediation, if the case does not settle, then the parties begin preparing for trial. Preparing for trial often includes preparing your evidence, preparing witnesses, and also having the court hear different pre-trial motions that the parties might need to be heard by the court. And then the final stage, of course, is a trial. There are 2 main types of trials: bench trials and jury trials. Bench trials do not have a jury, and they're just heard by a judge, whereas jury trials, of course, include a jury. At trial, the parties will have the opportunity to present their evidence and their legal arguments to the court, and then the court will make key and final decisions regarding the plaintiff's case. So this has been an overview of filing a lawsuit in North Carolina and the steps between filing a lawsuit and a trial. Of course, filing a lawsuit and the legal process in general is complicated. It's always best to work with an attorney. For more information, contact us at kriegerbrodish.com.